allow me to go through an historical excursus so that we can understand where we stand today. We can understand better where we are today with this historical overview. In 1937, a General Convention for the Prevention and Punishment of Terrorism was drawn up. However, this draft convention was only ratified by India, so not a great success. After this failure, those in favor of prohibiting terrorist acts took a different approach. Instead of striving to find a general definition, states and intergovernmental organizations chose the more modest approach of attempting to agree on the criminal nature of individual sets of specific terrorist acts. Thus, various treaties aimed at banning specific conduct at the universal level were drafted and entered into force. These include, for example, the conventions on the safety of civil aviation of 1963, the Convention for the Suppression of the Unlawful Seizure of Aircraft in 1970, the Montreal Convention for the Suppression of Unlawful Acts for the Safety of Civil Aviation, 71, the Convention for the Protection of Diplomats of 77, the Taking of Hostages, the Convention on Taking on Hostages of 79, and so on. So these were all sectorial definitions of very, very specific terrorist acts, and everybody could agree on those. Then there were also regional efforts, for example, the European Convention on the Suppression of Terrorism of 1977, that to promote a general ban on terrorism, but they were not universal. They were limited to a very specific geographical and economical area like the European Union. But they were actually, there was no more success in devising a satisfactory, comprehensive definition that would be valid for all the states of the world. It was only in the 1990s that this trend was partially reversed. First of all, there were so-called instruments of soft law, so not conventions, not binding resolutions, but things like General Assembly resolutions, which are not binding on states, but just give a very general indication of where the law might go. These were, for example, the Declaration of Principles of International Law concerning the friendly relations among states of 1970, and several others. And all of these, there were several ones in 70, 87, 91, that often complained about the lack of an agreed definition of terrorism. They, at the same time, were calling states to refrain from terrorist acts. But without, of course, a definition of terrorist acts, states were not sure what it meant to refrain from terrorist acts, because there was no clear accepted definition. In 1999, however, there was a very big, important breakthrough. There was a UN-sponsored international convention for the suppression not of terrorism, but of the financing of terrorism. This was adopted through General Assembly resolution, a General Assembly resolution in 1999. This convention finally added to some specifically enumerated acts, the ones we saw before about the civil aviation and so on, they added a general clause that says any other act intended to cause death or serious bodily injury to a civilian or to any other person not taking active part in the hostilities, when the purpose of such act is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. This convention is often referred to in the context of other UN activities in this field, such as the 1994 Declaration on the Measures to Eliminate International Terrorism, adopted by consensus by the General Assembly, which states that criminal acts intended or calculated to provoke a state of terror in the general public, a group of persons or particular persons, for political purposes, are in any circumstance unjustifiable, whatever the considerations of a political, philosophical, ideological, racial, ethnic, religious, or any other nature that may be invoked to justify them. So these two instruments, 1994 and 1999, despite their emphasis on the aims of the specified criminal acts, show that there was a generalized opinio iuris forming on the prohibition of certain criminal and violent acts that was consolidating around a core concept. Moreover, the possible justifications for such acts are not reiterated anymore, showing that the prominence given to the exceptions in the past is not important and is losing ground. It is interesting that various states have come recently to explicitly express the need to, and I quote, I will make a quote, to fight international terrorism in all its forms and irrespective of its motivations, perpetrators and victims on the basis of international law. End of quote. This is a statement by the government of Iran in 2011, for instance, which shows how the exception of freedom fighters is being gradually abandoned. Since 2001, we can see a shift in the UN response to terrorism. The UN Security Council passed Security Council Resolution 1373 of 2001, requiring states to prevent, suppress, freeze, and criminalize the financing of terrorist acts. In practice, what they were doing was to require the implementation of the provisions of the 1999 convention that I mentioned before, that was not yet in force. To refrain from supporting terrorists, to prevent terrorist acts and the use of their territory for international terrorism, and to deny safe haven to terrorists. Moreover, this resolution required states to criminalize the financing, planning, preparation, commission, and support of terrorism, to bring culprits of such acts to justice, and to assist other states in criminal investigations and proceedings related to terrorism. Terrorism is therefore now characterized as a threat to international peace and security in a generalized way, dispensing with the previous ad hoc approach which had characterized previous Security Council resolutions regarding terrorist acts. However, it has been noted that this type of Security Council pronouncements creates uncertainties as to the exact conduct that is required of states. Are states only required to establish jurisdiction over terrorism, or are they in fact required to actually initiate proceedings, criminal proceedings, against suspects? This remains a bit unclear. Allow me to add another Security Council resolution, Security Council Resolution 1566 of 2004, which mentioned certain acts that are never justifiable. These include criminal acts, including against civilians, committed with the intent to cause death or serious bodily injury, or taking hostages with the purpose to provoke a state of terror, intimidate a population, or compel a government or an international organization to do or to abstain from doing any act. Acts that constitute offenses within the scope of and as defined in the international conventions and protocols relating to terrorism. This is a very important development. Resolution 1566 is a resolution of the UN Security Council, binding every state that has freely joined the United Nations. The comments made by states in this respect are very interesting. For example, the government of Indonesia stated that, and I quote, "The United Nations universality of membership endows it with a charter-based legitimacy to overcome the threat of international terrorism in a manner which is inclusive, wherein states and peoples unite in solidarity. Moreover, it is to the United Nations that member states must turn to ensure that instruments for combating international terrorism are multidimensional in nature. Furthermore," and I quote again, "the importance of the work within the different organs and committees of the United Nations, including the General Assembly and the Security Council, in norm setting and in laying the legal framework for combating international terrorism is without question." And these are quotes from the Indonesian government, but they echo similar calls from various countries of diverse legal and cultural backgrounds. It is important to note that these statements do not come from we could call the usual suspects, such as the United States, the United Kingdom, Russia, and so on, the ones that are often described as the big powers interested in terrorism only against themselves. These calls against terrorism and in favor of uniting for a general common approach really do stem from the four corners of the world, so to speak. And these are all the elements that are showing that since the 1990s, and in particular since 2001, there has been a gradual shift towards a more common, generalized approach.